Good afternoon, everyone, and welcome to our meat locker. We've got the temperature down just so that you won't get overheated in this hot summer we're having here in Nashville. As judges, we have no control over the environment, as they say, inside or outside. But we're thankful you're here and apologize for the inclement weather that you're experiencing. We have 3 cases on the afternoon docket. We will hear them in the order in which they appear. Let me remind counsel that each side has a total of 15 minutes to argue, and that applies even if 2 or more lawyers are sharing that time. You have to divide it up. The appellant does have the option of reserving up to 5 of your 15 minutes for rebuttal, so to program the clock accordingly. When you get to the podium, let us know how much time to reserve, and the clock will be programmed for your benefit. With that said, please call the first case.
Marquica L. Beasley et al. Versus J. Nails Bar, LLC.
Good afternoon.
Good afternoon. May it please the court, Jacob Franklin, and with me is Lavelle Glanton on behalf of the appellants. I'd like to reserve 4 minutes at the end for rebuttal.
Very good, and we'll program the clock as you've requested. Let me add that we're pleased to allow you to argue on behalf of Mr. Glanton's client. Let me make one minor clarification. The Supreme Court rule requires a motion, and the document y'all filed says notice, but we're going to treat it as a motion. Do you have any opposition to his arguing the case?
I do not, Your Honor.
Very good. Then we'll treat the notice as a motion and grant it. So anyway, all right, so you have the floor.
Your Honors, this is a classic slip and fall case. It's an unfortunate one, in fact. Miss Beasley, she had her nails done by the appellees prior, and on a previous visit to the appellee's nail salon, Miss Beasley noted how nice the new countertops looked. At which point, the salon manager, who's known by many names, but Mrs. Beasley knows him as Eason, noted that he did the work himself. Miss Beasley, being a joker, thought he was kidding. He reassured her, no. He in fact did the work himself. Fast forward July 12th, 2018, Mrs. Beasley goes to the appellee's nail salon with her daughter to get some pedicures. While walking from the waiting area to the pedicure area after being called, Mrs. Beasley fell in what was a 10-foot by 9-foot area on the floor covered in dust, sawdust or residue, which, just for visual purposes, that's roughly the area of an average American bedroom. While falling, Mrs. Beasley yelled, and her scream was heard by both her daughter and Mr. Eason, who both came by and saw her getting up and quite literally dusting herself off and getting the sawdust material off of her dark clothes, which was completely covered in it. Mrs. Beasley, her ankle started swelling, and she told Mr. Eason, who saw her swelling ankle, that she would be going to the doctor. Additionally,
In Mrs. Beasley's statement regarding being injured, the brief indicates that was the court was alerted to that fact in response to the motion for summary judgment. Was that also part of the motion, the spoliation motion? In other words, was the court aware of the claim by Ms. Beasley that she was injured at the time when the spoliation motion was proposed?
I believe that is correct, Your Honor. And so Mrs. Beasley, when she's getting her pedicure done, she tells the employee who's doing her pedicure that, to be careful not touch her ankle because it's swelling, it's hurting, she's going to have to go to the doctor after. So that's 2 employees of the appellees who were noticed or notified that her ankle's swelling, saw her ankle swelling, and were told that she'd be going to the doctor after leaving. And then while leaving, Mrs. Beasley had to limp to her car with the assistance of her daughter. Thereafter, appellants filed a suit and eventually brought forth, as Judge McBride noted, a motion for spoliation, which was denied by the trial court. That foreshadowed the eventual granting of the appellee's motion for summary judgment.
Other than the conversation that you and Judge McBrayer just discussed on the day of the incident, was there any communication by the plaintiff or on behalf of the plaintiff with the defendant at all before the suit was filed?
Regarding the notice of the...
Regarding anything?
No, Your Honor.
Okay, very good.
So, I mean, at the heart here on the spoliation question, don't we just have a fact issue that apparently the court resolved in favor of the defendant here?
Correct. The court resolved in favor of the defendant despite and did not give sufficient weight to the two affidavits presented by appellants in the form of Mrs. Beasley's declaration, as well as the declaration of Mrs. Beasley's daughter, Ms. Hardy.
I'm sorry. Well, there's a second component. Your client and daughter say there was dust and it was on their clothes and what have you. But the other component, which the court seemed to rely upon, is whether the defendant business or any of its agents knew prior to the fall that there was dust or a dangerous condition. And your clients couldn't testify or didn't testify to that other than they discovered it once she fell.
That my clients discovered it once she fell. Yeah, that my clients discovered it once she fell. However, going to that issue, the the appellees, and as my client Mrs. Beasley testified in, and I believe it was her declaration, that, and as well as in her deposition, that Mr. Eason told her he was doing the work. So the trial court relied upon the fact, erroneously, respectfully, that because the appellee the owner of J Nails Bar testified that the private contractor had stopped work in May 2018, thus there was no way for construction residue to still be on the floor come July 12, 2018. However, that completely ignores Mrs. Beasley's testimony that Mr. Eason, the salon manager and boyfriend of the owner, had been doing some slight construction work and had been doing and remodeled the granite countertops. So that we have two separate issues here and not enough equal weight being placed on each thing. Going back to the spoliation in the first issue that we have before us is, let's see, obviously did the court err in in denying the appellant's motion for spoliation. This obviously is an abuse of discretion standard and will be set aside only when the trial court has misconstrued or misapplied the controlling legal principles or has acted inconsistently with the substantial weight of the evidence. And that is our position here. The trial court did not act accordingly and consistently with substantial weight of the evidence. As I laid out previously, Mrs. Beasley, she had notified two employees. They knew of this, that she fell. They knew roughly the size of the area where she fell at, and they knew that she was going to the doctor. So they have all of this knowledge, yet they never watched the video. They never preserved the videos. And despite knowing they had someone on their premises who was injured, who they saw the injury, they had firsthand knowledge that she was going to go to the doctor, yet they chose nothing. They chose to do literally nothing, not watch the video, not preserve the video. That is the classic definition of, or rather the classic situation where we should have a motion for spoliation granted. The second issue we have before us is the trial court erring by granting the appellee's motion for summary judgment by making a finding that was not argued by the appellee and was not supported by the record, which has been brought up earlier regarding the construction, when it stopped. Again, that goes back to, yes, they stated it stopped in 2018. The trial court erred in finding that because the private contractor stopped in 2018, that there's no way that this sawdust could have been there 2 months later on July 12, 2018. However, again, that ignores the facts that actually exist here, which is we have Mrs. Beasley stating Eason, the salon manager, told her he did this work. And we have sawdust on the floor. We have 2 witnesses.
How does that get us to, did he say he'd been working, 10 minutes before and to watch out for the dust? I mean, how does that get us that he done some work? How does that get us to the fact that they should know at this moment that there is dust on the floor?
Yes, Your Honor, good question. So again, it's a 10 by 9 square foot area. And this isn't some random person, stating this. This is Mrs. Beasley, who is a professional realtor. She's very well acquainted with what square footage is and isn't. And we're talking about a salon that's roughly 1,400 or 1,500 square feet. So a 10 by 9 area is, relatively speaking, a large portion of the salon. And keep in mind the layout where this area is from the waiting area to the pedicure stations. So it's a highly traversed area that both customers and employees have to walk through. It kind of defies logic to think that you can have this large, relatively speaking, large area that both customers and employees have to walk through, yet the employees would never know. That they would never know that this 10 by 9, this American-sized bedroom of sawdust materials on their floor, an area they have to walk through each and every day in order to go from.
So you want us to make an inference that this dust was there?
Yes, Your Honor.
Based on the fact that they should have known?
Yes, Your Honor. Again, we're talking a large area, and it's a nail salon. We're not talking a construction site where, people are going to have this stuff appear often.
Did the store manager tell Mrs. Beasley that he'd been doing this work before she walked through the area
That day?
that day?
No, Your Honor.
But, so when did she find out he'd been working on it then? After the accident?
At a previous visit.
So at a previous visit, she learned that there was work going on.
Yes, sir.
Wouldn't that be noticed to her to watch out?
Well, again, we're talking, there was no signs on the day she was in there.
No signs?
No signs of, hey, be aware of this. So, just because you're somewhere on May 31st doesn't mean you should all of a sudden, think, oh, hey, 2 months ago I'm going to walk in and I'm going to see residue.
Okay.
Going back to the spoliation issue, there was reference to a photograph taken by your client.
Yes, Your Honor.
How did that factor into the spoliation discussion?
As far as how the trial court viewed it?
Yeah, exactly. Your client says, well, I'm prejudiced by the fact that the videotape was deleted, but your client took a photo immediately after the accident.
Yes, Your Honor. Unfortunately, the way the photographs are, that's not the best evidence. The best evidence would have been the videotape itself. And again,
Isn't videotape a photograph, a moving photograph? You said your client's photograph wasn't the best evidence. Why would it not be as good as a videotape?
well, the videotape would have shown the construction work being done as well as Mrs. Beasley walking through it.
So you're wanting video of time before the fall?
We're wanting
Okay.
videotape of
Okay, I got you. All right.
that day.
Okay, very good. Thank you. You'll have time for rebuttal. Okay.
Thank you.
Good afternoon.
Good afternoon. May it please the court, Colin Calhoun for the defendant appellee, J. Nels Bar. There is no evidence in the record indicating that there was any construction work that was actively being performed at the time that Ms. Beasley's fall occurred on July 12, 2018.
Now, you say actively. What do you mean by that? Obviously not at the moment she fell, but Are you saying not the morning of or the day before?
Not the day before or even the days before, weeks before. The evidence establishes that the construction work had been completed in May of 2018.
But that was construction work completed by a contractor.
That's correct.
And
Your
what
Honor.
I understand the plaintiff's argument here is, well, there was that work, but there was additional work done by the, I don't know what you call a pedicure, office manager, or that were
Correct.
different time frame.
Keith Luke,
Is he the same as Eason? Is that the
he
one and the
is.
same?
His nickname is Eason, and you may even see his name in the record appear as Ethan as well, but it's actually Eason is the nickname that he goes by. That's the name that he's known by customers. And he's the significant other of the owner of J. Nell's Bar. Her name is Angie Hoang. And Ms. Beasley testified in her deposition that there had been a conversation that she had with Eason on a prior visit when she was there to get her nails done. Ms. Hoang had purchased the business from a prior owner in April of 2018, and Ms. Beasley testified that she had received nail services from Eason at a previous nail salon where he had worked. When she found out that he had left that nail salon and they had opened the new business J Nails Bar, she decided to continue getting services performed by him. And she had testified in her deposition that she had had a discussion with Eason on a prior visit. It's not clear. She doesn't know what date this conversation happened. She testified that she had been there at the salon, J Nails Bar, 1 or 2 times prior to July 12th. And they had had some discussion about the remodeling work that had been done, and she had questioned him about who had done the work. It was complimentary of the space. And she testified that he told her that he had done some of the work himself, and she wasn't sure exactly what it was. It was, it might have been installing some granite countertops or possibly installing flooring. And this was, again, on a prior visit. And there's no indication from the testimony that she actually observed work that was in progress at the time of that appointment, whenever that was.
So you're saying that the work that Eason, or I hate to call him Eason, Mr.
Luke.
Was completed also by that same May timeframe, May of 2018?
That's my understanding. There's nothing in the record, no evidence in the record that indicates that there was any work that had actually been completed by Mr. Luke at some point between May of 2018 and the date of the fall.
Was there any evidence in the record that indicates what the residue on Miss Beasley's pants was after her fall?
There is not, Your Honor. Mr. Luke, he testified that he inspected the area after her fall. He didn't see the fall, but he heard the fall. He walked over to Miss Beasley when it happened, and he inspected the area. He testified that he didn't observe any slippery substance on the floor, no water. He didn't identify any dangerous condition on the floor that could have caused her to fall.
Did he respond to a question of whether there was dust on the floor or on the plaintiff's clothes?
He was asked that question in his deposition, and I know that his testimony indicates that he did not see any type of dust, slippery substance, or residue on the floor, and with respect to her as well. And after her fall occurred, she did not have any communication with Mr. Luke or Ms. Hoang at any point in time thereafter, indicating that she was injured such that she would be pursuing a personal injury claim or filing a lawsuit. No phone call, no written communications, and she didn't dispute that. She admitted that in her deposition.
Did she come back as a customer after the fall?
It's my understanding that she did not. She'd never returned to the salon at any point to discuss the fall or to otherwise have nail services performed.
So no communications or opportunities for communications after the day of the incident?
That's correct. And J. Nails Bar did not receive a notice of representation, evidence preservation letter from any attorney on behalf of Mr. and Mrs. Beasley as well.
And obviously the trial court relied heavily on those facts in making the determination. I guess what I'm confused about is that you have Mrs. Beasley supported by her daughter apparently making this claim that she actually shared, contrary to what Mr. Luke was testifying, or what his affidavit said, that she was in fact injured and her ankle was swelling, and to avoid that area when performing the pedicure. But the court doesn't reference that at all. So, I mean, how was that presented to the court? Why is it not dealt with in the court's order in some way?
I can't speak to why the trial court didn't discuss that in the issue. It was part of the briefing, the evidence. Ms. Beasley, in her deposition, she stated that she didn't recall one way or the other if she had indicated to Mr. Luke that she was injured at the time of the fall. Now, she did indicate in her deposition that she complained to the technician who performed her pedicure that her foot and ankle, I think, was hurting and swelling. She did state that, if I'm not mistaken. And Mr. Luke had testified that when I asked her if she was okay twice, she reported to me that she was okay on each such instance. And with respect to...
And that was obviously on the day of the fall.
That's correct. And something I will point out regarding that question, Your Honor, the trial court in the order regarding the spoliation issue states that the court finds there's nothing in the record to suggest that J. Nails Bar knew or should have known that the videotape in the case at hand was relevant to pending or reasonably foreseeable litigation, as they were not put on notice that the plaintiff was injured to the extent that she planned to file a lawsuit. So I take that statement to mean that the trial court was deferential to Ms. Beasley's testimony that she at a minimum had reported injury to an employee of J. Nails Bar while she was there on that date.
But that was not enough in the court's view to put them on some
That's
sort
correct.
of...
I feel that language in the order indicates the trial court accredited her testimony that she reported injury to J. Nails Bar on the date of the fall, but she should have done more. She didn't do anything.
Okay, and this went off solely on declarations and affidavits. The court didn't say, no one said, look, we need to have an evidentiary hearing here, nothing like that.
Correct. There was no evidentiary hearing, just deposition testimony and affidavit testimony of Mrs. Beasley and her daughter, and declarations from Mr. Luke and Ms. Hoang. That's correct. But I respectfully submit that the trial court did appropriately conclude that spoliation sanctions were not appropriate and focused on the totality of the circumstances based on the Tennessee Supreme Court's holding in the Tatham case from 2015, which involved a products liability case against Bridgestone when a tire blowout occurred that caused the plaintiff to have a motor vehicle collision on the interstate while passing through Jackson on I-40. And that tire had only been on the vehicle for about 3 months. It was a relatively new tire. The plaintiff in that case had received advice from her automobile insurance carrier to go ahead and sign the title over to the wrecker for your vehicle. And of course, the defendants in that case complained that they didn't have an opportunity to properly investigate the condition of the tire. And even in that case, the court concluded that spoliation sanctions were not appropriate. And there's no evidence that Jane Elsbar intentionally did anything to erase or delete surveillance video footage. No indication that there was any intentional or fraudulent conduct whatsoever. And the plaintiffs are not able to demonstrate any prejudice. Ms. Beasley actually took a picture after she fell before she left the salon, attempting to capture the dangerous condition that she alleges caused her fall. And that picture is really clear. Really clear picture of the tile floor that's in the record. And that photograph of the floor does not show the presence of a dangerous condition that could have caused her to fall. She secured good evidence before she left the salon of what she alleges caused her to fall. If a camera is not going to show it, if a photograph's not going to show it, camera's not going to show it either. And there's no dispute that she had a fall.
You mean a video camera?
I'm sorry, a video camera versus a camera on her cell phone. And there's no dispute that she fell. Obviously, she contends that she might have been able to show or demonstrate what caused her to fall if some surveillance footage existed preceding the fall. But the trial court clearly did not err in denying the plaintiff's spoliation sanctions, and there's nothing from which this court conclude. I respectfully submit that the trial court acted inconsistently with the substantial weight of the evidence. With respect to the trial court granting the motion for summary judgment, I respectfully submit that the trial court properly granted summary judgment. There's no evidence in the record showing that Jane Elsbar or any employee or agent of Jane Elsbar created the hazardous condition that Ms. Beasley alleges caused her to fall. And there's no evidence in the record from which the court can conclude that Jane Elsbar had actual or constructive notice of a dangerous condition that would have caused her to fall. Also, the plaintiffs aren't able to show that there was any type of continuous condition, a recurring incident, or a pattern of conduct with respect to the salon that caused the floor to be in a dangerous condition such that the customers of the nail salon were confronted with a hazardous condition when they were walking on the floor to a nail station to have their nails done.
And let me go back to one thing about whether or not an individual was doing some modest construction work. It's your view that there is no evidence at all that this gentleman did any work on the day of this incident or the day before or the day before that or even the week before that?
Yes, Your Honor.
Okay.
That's correct. I don't have anything further absent
All right.
questions.
Very good. Well, thank you for your argument. We'll hear from the appellant for rebuttal. Yes, sir.
All right, so just to address a couple things. First off, as far as the floor and the sawdust being on there, Mr. Eason or Mr. Luck, as he's known, He testified that he regularly cleaned the floors each day. So
Do we know it was sawdust? Was there testimony that it was sawdust?
it was some sort of dust or fibrous material.
Yeah, that sounds like two. What is the plainest theory about what happened here? Fibrous material and dust seems like two entirely different things
It's
to me.
our theory that it's from the construction. So
Okay. And it's
sawdust.
something Mr. Luke worked on.
Yes, Your Honor.
Okay, so the theory is it's sawdust.
Yes, Your Honor.
And that's what adhered to Miss Beasley's pants. And what is the plaintiff's contention about when that work occurred? When Mr. Luke performed that construction work?
So, as far as the specific time, we don't know that because we weren't there when he was doing the work. However, that's why the video is so important. So, opposing counsel mentioned a photo was taken, as we discussed earlier. The photo, it's not the best photo. Mrs. Beasley is a realtor, not a photographer. She didn't take a great photo. However, the video would have shown, again, in his deposition, Mr. Easton testified that he cleans the floor daily. Well, the video would have shown whether he cleaned it or not. Moreover, we're talking about a 10-foot by 9-foot area. If he's cleaning it daily, how are we getting such a large area that has this sawdust material all over it? Because again,
How do we know it was all over?
well, again, we have the testimony of Mrs. Beasley and her daughter.
She says it was all over.
Yeah, 10 foot by 9 foot, yes, sir.
Okay, but she didn't see it before.
Correct, because when she walked in, she went
What-
and went to the waiting area.
If I were to go to a law library and open up a legal encyclopedia, what would it tell me? What circumstances trigger the obligation to preserve evidence?
Well, you have to, it goes back to, knowing that there's pending litigation or reasonably foreseeable. Again, when you have someone come on your premises, they get hurt, are firsthand knowledge that they're hurt, you see the injury, and they're telling you and other employees of the premises that they are going to the doctor, that's kind of a ringing indication that, hey, we probably need to, at the very least, check on
So
this.
you can tell that to any employee, and that's good enough?
Well, again, we're not, Your Honor, we're not talking about just any employee. We're talking about Mr. Luck, also known as Mr. Easton, who is not only the
I
salon
thought
manager.
his testimony said she didn't say anything to him.
This is where we get a genuine issue of material
I
fact.
thought her testimony said she told the lady working on her foot.
No, Your Honor. She told both Easton as well as the lady working on her foot that she was hurt and that she
Okay.
would be going to the doctor.
So was there a request with the trial court to say, Your Honor, we've got competing affidavits here, let's put on proof so you can make a factual determination of who you believe here?
As far as an evidentiary hearing, no, Your Honor, there was not that. But then again, this goes back to genuine issue of material fact, and this is something that is ripe for a jury to be deciding. Or as it was brought up previously that Mr. Easton or Luck, he didn't see the dust on Mrs. Beasley. Again, we have the competing testimony saying he did. There's also competing testimony. He's saying that she said she was okay. Mrs. Beasley's daughter testified that he never asked if she was okay and that she testified, that she stated she was injured. Any questions, Your Honor?
No, thank you very much. Thank you both for your arguments. We'll take this case under advisement.